Hello, I'm Peter Towers, Managing Director of ESS BIZTOOLS. Welcome to this webinar. Offer a proactive personal property securities register service. If you have any questions during the webinar, can you please type in your question and send it through to us, and I will answer your question during the webinar. First area I want to start with is risk management. It's an area that accountants are very familiar with in helping SMEs. And my question really is, are you considering personal property securities register in the same manner? Accountants treat insurance as a key risk management area, look at business risks for a client in a whole range of activities. Commercial compliance is obviously very important. Legal matters. Whilst not giving legal advice, you might have ensured that your client makes an appointment to see an appropriate legal advisor on whatever a particular issue is. Environmental risks at times require expert opinions and maybe some assistance by you in advising your client to talk to someone. And corporate governance, obviously, company directors' duties, company secretaries' duties, even company officers' duties, you give advice on. But what about personal property securities register? This is another major risk. In fact, some people would argue this is a very significant risk for every business in Australia. This legislation commenced in January 2012. There was a phase-in period which lasted 2 years. But it is a significant risk area, not only for small, medium enterprises, but also for major businesses. And that's proven in that over $400 million has been lost by businesses, both large and small, in Australia, because they failed to register on a government register. I've spoken to a lot of small, medium enterprises about this legislation, and many of them cannot understand why they have to register an asset that they own or they are acquiring through lease or lending finance from a bank, why they have to register on a government register. There was an inquiry conducted by the federal government about 18 months ago, and that found that the vast majority of small, medium enterprises did not have any real knowledge of how this legislation operated. Unfortunately, ignorance of this legislation can be a quicksand effect. Your clients really don't know that they've got a problem under this legislation until an event has occurred with someone else. A liquidator has been appointed and your client could lose a lot of money. In fact, your client could lose their business in some circumstances. One of the real issues for a lot of people, including some accountants, is what is actually covered. It's all property other than real estate. So it most definitely is business property that is covered under this legislation, even though the government chose to call it personal property. There's a vast range of business property, because that's the terminology I'd prefer to use, that can be caught under this legislation. Stock, plant and equipment, crops, intellectual property. I'm just reading a question here, and I'll just read it first. I'm unsure how the PPSR. Okay, I'll be talking about how it applies to trade debtors shortly. Thank you for that question. Crops, intellectual property, motor vehicle, livestock, and debtors. And we'll talk about debtors in a short while. But there are other things. There's assets like paintings, rare carpets, sculptures, could all be caught under this legislation. So the key matters to discuss with your client are the terms of trade agreement and the retention of title agreement. These agreements should be prepared by a commercial solicitor, and your client should have had these since January 2012. Liquidators have told me that they believe many people have not got these. I really would be suggesting that you review your clients, and if they have not got these agreements, that you encourage them to see a commercial solicitor to have these agreements put in place. And once they get these agreements, what is then happening? And this is really going to the crux of the question as to what I believe an accountant's role is with the PPSR. Some accountants have said to me that they believe it's a legal issue, the whole total package of PPSR. I tend to disagree. When I talk to solicitors, they tell me that all they're interested in doing is preparing the terms of trade agreement and retention of title agreements. They don't go out and check what the client's doing relative to the implementation of an appropriate system, a system that would ensure that this particular item has been attended to. When a business signs on a new customer, are the terms of trade and retention of title agreements being sent? If so, by whom? And most importantly, are these documents being returned by their new customer before any goods or services are supplied? Then your client needs to decide whether to register that customer on the PPSR. And this must be done before any supply is made, because that registration has to be made within 15 days. In our system, we have a process to suggest that your client might work through to decide whether they will register a particular customer. Because if a customer is going to be very small or below a certain amount of money, then your client might decide not to register that customer. That's a business decision that your client needs to be making, but they need to be thinking about it and just not ignoring it, because undoubtedly that will be the one that slips through. So is there a system? The decision whether to register is very important, and this has to be considered on a customer-by-customer basis. If you're going to register, registration must be completed within 15 days if you're supplying stock. If it's matters to do with intellectual property, 20 days. So have your client systems been reviewed lately? Has your client got a system to ensure that they are abiding by the rules to protect themselves on the PPSR? Does your client lease assets to others? And there's some terminology that comes into play here. Indefinite period can be a trap, because if the indefinite period exceeds 2 years, that becomes a PPS lease. And if a client wants protection, they should be registering that customer. Is it a lease for up to 2 years that's automatically renewable at the end of the 2-year period? Now, the 2 years used to be 1 year, and when this legislation first started, it was only 90 days. But it's now 2 years. It's been 2 years since May 2017. So if you've got leases that are up to 2 years that can be automatically renewed, and it's a matter that could cause some financial embarrassment if it wasn't registered, then your client needs to have a record of this so that when the 2 years is up, they can register that agreement. And if the lease is for a term in excess of 2 years, it's a PPS lease, and therefore, if they want protection, they need to have registered on the Personal Property Securities Register. I think it's a good question, and it's a good place to start. And we're going to look at one of the key forms within our system shortly. But where were your clients' assets last night? Because that's where I suggest you start if you're going to undertake a review with your clients. Where were your assets yesterday? Were they on your own premises that your client owns? If so, there's no problems under the PPSR. But if they're in someone else's premises, and probably putting it another way, if they're on consignment, there is a potential problem. If something goes wrong, if a liquidator, receiver, or trustee in bankruptcy is appointed, and that brings us to insolvency events. If a liquidator is appointed to a customer or the owner of premises where your client's assets are located. So there's two aspects here. The first one is a customer, a debtor, or the owner of premises where your client's assets are located. And the assets could be anything. It could be stock, could be vehicles, could be plant and equipment. In that situation, first of all, for a customer or a debtor, this could lead to a demand for repayment of alleged preferential payments. If the liquidator believes that in the 6-month period prior to their appointment, that your client was receiving preferential payments, and under the legislation, the liquidator is supposed to prove that, but there are some allegations in the marketplace that liquidators basically send letters to anyone that received payments in the previous 6 months and demand a repayment under the preferential payment category. So if any of your clients receive a demand for preferential payments, they should, I think, see a solicitor very quickly and have some questions go back to the liquidator. But there's been all sorts of demands being made under this category heading, preferential payments, which go back for 6 months. And if it's the situation that the property owner has a liquidator appointed, if your client's got assets situated on those premises, they could lose ownership of those assets if they are not registered on the PPSR. Because I understand from talking to liquidators, basically the first thing they do these days when they get appointed is conduct a stock take of what is on the premises that they've been appointed as liquidator to, and then they check on the Personal Property Securities Register to see if anyone is registered those assets. And if not, they are potentially claiming them for the benefit of the secured creditor who has appointed them. There's been cases where these insolvency events have caused extreme financial difficulty for clients, business owners. If your client had registered their customer on the PPSR or the owner of the premises where they had stock, plant, other assets stored, in most likelihood, they will avoid any problems under the PPSR. If they haven't registered, they've got a very weak case. About the only way they're going to be able to argue is that the payments they received was not a preferential payment. Our recommendation is you act now. You encourage your clients to understand the benefit of an annual system review. Or if they haven't currently got a system, that you set up a system within their business, which obviously will have to take into account the actual operating environment in which your clients operate their businesses. But someone should be put in charge of this process. In the first instance, that person's role is to make sure that the terms of trade and the retention of title agreements are sent to the customer for signature, or the new customer for signature. You don't have to do this for every new transaction, as long as the transaction is the same type of transaction as the one that you have the agreements for, that they have the agreements for. But if they vary them, they need new agreements. We believe it's important to have a conversation with clients and potentially put them into industry groups so you can really zero in on the matters that are affecting a particular industry. So we've grouped these as subcontractors, primary producers and farmers, wholesalers, retailers, principal contractors, and others, because there are some very significant peculiarities that apply to these type of businesses down till we get to others under this legislation. Now, our recommendation then is that you invite the clients in their industry groups to a seminar or webinar whereby you can have a discussion with them and outline to them the type of reviews that you're able to undertake. Incidentally, in the review process, our recommendation is that you talk to your clients about making sure you get notified if there's a change of staff person who's responsible for the PPSR within your client's business. Because if that person leaves or goes on holidays or is absent for illness, someone else is going to take their job. Does that person clearly understand what they have got to do? Because little things can be very significant under this legislation. I was in a legal office in Sydney a couple of years ago, and the partner was telling me of an instance whereby one of his clients had come back in and admitted that they had lost a couple of $100,000 under this legislation, but it could have been a lot worse, because at one stage that customer owed their client a couple of $1 million. And the problem was that the person preparing the PPSR registration had misunderstood the terminology grantor and grantee and got the terminology mixed up. And therefore, none of their registrations on the PPSR for the previous 2 years would have been effective. They only had the one case that had occurred, and they did not have an effective registration. So there's very small issues that can cause significant problems under this legislation. I think at these seminars, webinars, you would then discuss the extreme risk areas that apply to some of these industry groups. For argument's sake, subcontractors, the preferential payment claims is one of the big areas, because that's something that can really sneak up on a subcontractor. And the other ones are, protection of their tools of trade, etc. But the big one, I believe, for them is preferential payment claims. I don't think anyone wants to see any of their clients lose a lot of money under this legislation. I'm just checking. So you would want to ensure that your clients have an appropriate system so they don't lose funds because they haven't registered on this government register. Obviously, we believe that an annual review is a must. We'll only take a couple of hours just to go through and check that the system is functioning satisfactorily. You ensure that the notes that the staff person are using are up to date. It's very important that there is system notes so that if the person is absent or on holidays or leaves, that the person taking his or her place has some sort of written system in front of them so they understand how the whole process of PPSR works. The actual registration fee on the PPSR is very cheap, about $6.40 for a 7-year protection, probably the cheapest insurance policy that's going. Obviously, it's going to cost the client some money because they'll need staff who are responsible for the PPSR. And if the client has elected that they are going to do their own registration work, well, that work must be a high priority within their organisation. We therefore believe that the PPSR review is something that should be available and you should be talking to all of your business clients about, that it should be conducted at least annually. We're now going to show you the form which we've developed within the ESS BIZTOOLS Personal Property Securities Register system. We refer to it as BAS 165. It's a different BAS to the one most of you might be used to dealing with. We call it Business Advisory Services. This is the key document, and first of all, we're asking, what personal property does your business own? And we make no apologies for putting personal property in inverted commas. Why the government can call it business property, I got no idea. So that's a list of some of the assets, and we might just work through some of these questions, because this is the form that we recommend that our clients, our accountants, use with their clients in understanding where everything was last night. And we have deliberately included a fair bit of explanatory information because in my actual experience with some clients, you ask them about stock, some of them will forget their consignment stock and their demonstration stock, etc. And the key thing is, where is the stock? If it's on their own premises, there's no worries. But if it's on leased premises, someone else's property or out on consignment, there are potential problems if a liquidator is appointed. So then we want to know, have they entered into a terms of trade agreement? And our recommendation to you is that you should immediately indicate to them they should get legal advice. Same with the retention of title agreement. And it's very important that they do explain to their solicitor what they are doing in their business. I've noted that some businesses end up with more than one type of agreement because of the different types of clients that they're servicing. We deliberately showed livestock and crops separately. Now, didn't just call it stock, so that for people who have got some other assets as well as livestock, it's very clear to them that these are assets to be looked at. Might be livestock that's on adjustment. We've particularly put thoroughbred horses because there was an infamous case in New Zealand. Yes, New Zealand has this legislation. We basically copied them. and a racehorse over there worth over 2 million New Zealand dollars was forfeited to the liquidator. So we've particularly highlighted thoroughbred horses. And then we looked at goods. Are goods left in someone else's possession? Goods sold on behalf. Goods attached to other goods. So your client can get some protection under this legislation that they basically couldn't get previously, prior to this legislation coming into being. So goods attached to other goods that they cannot repossess, they can now get some protection, obviously when the customer still owes them money, so through their debtors. There's also particular rules for mixed goods. So that's where you have a situation where grain is supplied to a grain silo. It's obviously mixed with other farmers' grain. Or products are supplied to, say, a bakery or a biscuit manufacturer where they're buying various products and they're all then getting mixed. There is potential protection for your client if they have registered that customer on the PPSR. And if you have clients who are selling products that are used for growing crops, so the products such as seeds, fertilizers, pest control, they can get protection under the PPSR. We've got a special section in here for artist works. And again, this is trying to clearly illustrate that the word stock could cover a whole range of matters. And there was a incident in Auckland shortly after the legislation started in New Zealand involving a large quantity of paintings, sculptures, carvings, works of art that were in someone's premises and a liquidator had been appointed. We then come to plant and equipment. And again, we have tried to itemize what might be covered. And then we start looking at leases, plant and equipment that's been leased to someone. Now, we've introduced into our system two components of leases. The first is if it applied after the 20th of May 2017, which, as I've indicated to you before, is a 2-year lease. So when you look at lease situations, if your client's leasing something for up to 2 years, they don't have to worry about it. But if it's an indefinite period, they don't have to worry about leasing it until after it goes over the 2 years, but they need to have a record to make sure they're aware of that. If it's a lease of up to 2 years, automatically renewable. And if it's a term of more than 2 years in the first place. And they're the ones that they need to be aware of. Obviously, the sum of money comes into play and undoubtedly who their client is. But I've heard some people say, oh, they're a listed public company, we won't worry about them. But unfortunately, some listed public companies get into difficulties at times. We then look at plant and equipment that was entered into an agreement before the 20th of May 17 when the 1-year rule applied. And we look at motor vehicles. And we look at boats and other types of watercraft and so on. I'm just going to skip through a few of these because there's some other areas that we look at aircraft. Anything with a serial number on it has to be registered under this, or can be registered under this legislation. You might have other physical personal property that's at someone else's property. Debtors, our system has a complete summary on the position on debtors. This is the final checklist. what you have to be aware of is that I'm sure you've noticed many SMEs are still using Ramalpa clauses, basically in the same wording that were there prior to January 2012. They're not worth the paper they're written on these days. We've got summaries on the unfair preferential payment situations. Licenses and trademarks can come into play under this legislation. So if you've got a client who has entered into an agreement to license the use of their trademark to someone else or a license, I suggest that they should be talking to their solicitor about getting that registered on the PPSR. Intellectual property, even loans. Assets held on trust by other people. Think about your clients who are trustees of superannuation funds. Where are their assets held? On whose premises? There's been a situation involving a loss of over $2.25 million, which basically sounded like a service entity arrangement. One company owned the plant and equipment, rented it to another company in the same group. Presumably, no one in the first company was aware that the second company had borrowed a substantial amount of money from a bank. They got into difficulties in repayments. The bank appointed the liquidator. The liquidator seized $2.25 million worth of plant and equipment. Company one turned up with a team of men to take the equipment back, which is all earth-moving equipment. They were met at the gate of the premises by security guards, and the Supreme Court of Queensland ruled that the liquidator was within his rights to seize that property and to sell it for the benefit of the secured creditor. You wouldn't have wanted to be the accountant for that group, I don't think. And we've got some question there on some other personal property, because this really gets back to superannuation funds. Rare coins, rare stamps, rare carpets, paintings. Where are they? On whose premises? So that's some of the material that we have included. I'm just going to check to see whether there's any other questions. I can't see any at this stage. If you do have questions, can you please send them through to me, and I will attempt to answer them. If you think of any questions later on that you would like us to comment on, you can send me an email, and I'll give you the details of that in a moment. So that's the overview of the product we've got that's contained within ESS BIZTOOLS. If you're interested in making a subscription agreement with us, our gold package, which includes the PPSR and all of the other material which we have on a significant range of products, is available at a special discount through to the 28th of February to celebrate the launch of crowdsourced funding in Australia. And we have a special webinar on crowdsourced funding in a couple of weeks' time. Or you can just subscribe to our Personal Property Securities Register product package. That subscription is $550, including GST. And it covers all of the material that we have to assist you to be able to offer a Personal Property Securities Register service. I would welcome you visiting ESS BIZTOOLS. You can have a look at our material. You can look at the standalone product at ESS BASIP. From around the end of February, ESS BASIP is being merged into the new website for ESS BIZTOOLS, but at this stage, you can most definitely go onto the ESS BASIP website that's shown there and have a look at the promotional material that we have there for the Personal Property Securities Register system. If you think of any questions later on, please send me an email, peter@essbiztools.com.au. I'm just going to check whether there are any more questions. I hope, Michael, that you have an understood. I've explained how the debtor system works. Obviously, it's a complicated area. Our system includes material on how you should advise your clients and the processes they need to be aware of when it comes to their dealing with their customers, because this is an area that a lot of money has been lost by primarily subcontractors all around Australia. And every so often, newspapers all around Australia publish articles. A lot of the commentary is criticising the state governments for the problems relative to mainly the building industry, but that's not going to help an individual client. The only way that I know that the individual client, the subcontractor, can be protected is if they have registered their customer on the PPSR. They need solicitors to draft the agreements for them, and they need to be insisting that their customer signs the agreements so that they have then the legal right to proceed with the registration of that customer on the Personal Property Securities Register. If the customer refuses to sign, I would really be questioning whether your client should be entering into a transaction with them, especially if it's a considerable sum of money. Or you can telephone me if you wish to have further discussions on 1-800-232-088. So thank you very much for your participation in this webinar today. We have taped the webinar. We will be sending you a link on YouTube to access the tape of the webinar in the next couple of days, and we will also send to you a copy of the PowerPoint slides that we've used today. We would welcome your visit to our sites. You can go to ESS BIZTOOLS and apply for a guest login. That lasts for 30 days, but that special price that we've indicated to you today does finish at the end of February. So if you are inclined to register with us as a subscriber, and we would love you to do so, please do so before the end of the month. Have a great day. Goodbye.